Judge, the matches are in a breakout room right now. Oh, it looks like they're popping out.
Okay.
Could you please make me co-host?
No, ma'am, I'm making you host again.
Okay, thanks.
Good morning. Today is Wednesday, February 9th. I am Judge Martin. This is courtroom number 1 of the 34th District Court. My docket today is all landlord tenant. If you do not have a landlord tenant matter, you are in the wrong courtroom. Please check your notice and get to the right place. If you're not sure if you're in the right place, you can send a chat and my secretary will look into it. Mary Ann, you were starting to say that you have a match.
Yes, attorney, I'm gonna say your first name because I don't want to butcher your last name. Ryan has 2 matches. They are
And
Parks of Belleville and versus Brown and McLaughlin.
thank you, ma'am.
You're welcome.
We have 214743 LT. This is Parks of Belleville versus Vita Brown. May I have your appearances, please?
Ryan Wojcik, P84535, on behalf of Parks of Belleville.
Yes, I'm here for Vita Brown, Theodore Daniels.
And
We
Mr.
also have-
Daniels, how are you related to this property?
That's my mother.
And where is your mother?
She's not available. She's out of town right now.
Your Honor, he is a listed occupant on the lease.
He's a listed occupant on the lease, but he's not included in the summons and complaint for some reason?
He is under and all occupants. We don't demand people who are not lessees. Maybe to streamline this a little bit, Your Honor, he was just, Ms. Brown was just approved for Sarah funds this morning.
Let me stop you for 1 second and then I'll get the Sarah number from you, okay? The reason why we're here this morning is that there was a Sarah stay put in place back on November 10th, 2021. That stay is only for 30 days. Plaintiff's office did submit a request to lift the stay. 91 days have passed. My next question was going to be, what is the status of the Sarah funding? And you've indicated that he's been approved.
Yes, as of this morning, according to my manager, Terry Torres, who is also here.
So is your intention to adjourn this matter out again, or have you
Yeah.
discussed a conditional dismissal with Mr. Daniels?
I'd be happy to do either. In the breakout room, we did discuss just adjourning 2 weeks. If we'd like to just get a control date on there, and then I can get a conditional dismissal in, unless you need us to place that on the record.
Mary Ann, what's the 23rd? No, Mary Ann, I have to go grab some calendars. Hold on a second.
Okay. Mr. Robinson, can you hear me?
Hi, Mary Ann.
Hi, good morning. How are you?
I'm well. How are you?
I'm great, thank you. Hey, Miss Spencer is here. Do you need to go out into a breakout room with her?
Yeah, you know what? I just texted my client. Can you see if he's on or not? Evergreen?
There's somebody that's unidentified in the waiting room. I'll bring them in.
No, I don't think that's it.
Okay,
Yeah, you can put me in a breakout room with Ms. Spencer.
okay, Miss Spencer, you're gonna see join the breakout room, please.
Okay.
Our next landlord tenant date is March the 23rd. This matter will be adjourned to March the 23rd, 2022 at 9 a.m. back in virtual courtroom number 1. Anything else in this matter on behalf of the Parks of Belleville?
No, Your Honor, I just want to clarify, if we do enter into a conditional dismissal, do you still need us to appear for that court date?
Absolutely not. You just email it to the civil department. They'll get it upstairs to me.
Great, thank you so much.
Anything else, sir?
No, Your Honor.
Anything else, Mr. Daniels?
No, ma'am. Thank you.
We're all set, sir. Have a good day. You may log off.
All right, you too.
This is 214840 LT. This is Parks of Belleville versus Maurice McLaughlin.
Ryan Wojcik, P 84535, on behalf of the Parks of Belleville LLC.
McLaughlin,
Yep. Yeah. I'm here.
state your name for the record, please.
Maurice McLaughlin.
Thank you. Today is the day and time set for hearing on the plaintiff's request to lift the Sarah stay that was put in place on November 17, 2021. That was 84 days ago. What's the status of the Sarah application?
I actually talked to a lady last week, and it's like one step further. I've tried calling today, but I don't think they're open just to make the decision on accepting it.
Mr. Wojcik?
Yes, so my understanding is that the Sarah has still not been approved or denied. It's been more than 45 days. He's also not been in contact with my manager at the property, which is, of course, an issue when the balance is growing. I believe at this point in time, we would request a judgment. If he receives funds, obviously, we'd be happy to take funds rather than, order a writ.
Mr. McLaughlin, the attorney for the parks has cited the administrative order accurately. More than 30 days has passed since the Sarah stay was put in place. There's not been a decision made and funding has not been received by the plaintiff. For that reason, plaintiff is entitled to entry of judgment. What's the rent to retain, please, sir?
The rent to retain on Mr. McLaughlin is $5,741. $40.81. So it's $5,740.81. Costs in the amount of $164 for a total due and owing of $5,904.81. I can, of course, provide a judgment to this court. The writ date would be February 21st of 2022. Partial payment will not prevent the court from issuing the writ.
Mr. McLaughlin, do you dispute that the rent due and owing is $5,740.81?
I don't dispute it. That's correct.
Okay, sir, inasmuch as the Sarah funding has not been approved or denied as of yet and funds have not been released to the plaintiff and you do not dispute the rent that's due and owing, judgment will enter in favor of plaintiff and against defendant with rent to retain possession of $5,740.81. There's $164 in cost for a total of $5,904.81. Plaintiff's office may email or snail mail that judgment to the court for entry. Anything else in this matter on behalf of the plaintiff?
No, Your Honor. Thank you.
Anything else, Mr. McLaughlin?
No, thank you.
Thank you. We're all set, Mr. McLaughlin. You may log off. Have a good day, sir.
All right, thank you.
Thank you. Mary Ann,
Yes, ma'am.
who else? Who's ready?
I'm ready, Judge.
Mr. Robinson, was that you?
It was. Good morning, Judge.
You're not ready. No. (220050) LT. This is Brookdale Farms versus Gailey Irvin.
Oh, actually, Judge, I thought you were going to call Evergreen because we're in the breakout room with Ms. Spencer. On Evergreen.
Thank you, Mr. Robinson. 220217 LT Evergreen Town and Country versus Alicia Spencer.
Good morning, Your Honor. For the record, Steve Robinson appearing on behalf of Evergreen Town and Country.
Ms. Spencer, please state your name for the record.
Hi, yes. I am Alicia
State your
Spencer.
name, ma'am. Thank you so
Alicia
much.
Spencer, sorry.
That's okay. Today is the day and time set for the second hearing in this matter. The first hearing was on, or the pretrial was on February 2nd, 2022, at which time Ms. Spencer failed to appear. Based on her failure to appear, clerks mailed notice for the parties to appear today. Mr. Robinson, how are we proceeding?
Your Honor, Ms. Spencer has just given me a Sarah number. So I can give that to the court and we'll do the 45-day stay.
That Sarah number, please, sir.
It's 493861.
Ms. Spencer, inasmuch as you've applied for financial assistance through the SARA program, this court is required by administrative order to stay these proceedings. You will receive a copy of that stay from the court clerk that indicates that the plaintiff may ask the court to lift the stay and reschedule the matter for hearing if they have not received either funding or a decision on your application for funding within the next 45 days.
Yes, Your Honor.
Anything else in this matter, Mr. Robinson?
No, Your Honor, thank you.
Anything else, Ms. Spencer?
No, thank you, Your Honor.
Okay, ma'am, we're all set. You may log off now. Have a good day.
All right, thank you, you too.
Thank you.
Your Honor, on the other town and country, the Evergreen Town and Country I have, it's Bingham. That's going to be a dismissal.
Have you sent it over yet? You said it's going to be?
Yeah, I'll bring it over today, Judge.
220218 LT Evergreen Town and Country versus Sarah Bingham is going to be a dismissal. Mr. Robinson will bring it over. And then on the other case, the Brookdale Farms.
Yeah, Judge, if you could just pass on that for now, I just got to contact my client. She just texted me.
Absolutely,
Thank you, Judge.
absolutely. Mary Ann, were there other match sets?
Judge Richard Herman,
Nope,
no match set.
nope. Mr. Hermit, you are not Mary Ann.
Good for her.
Actually, I was going to say, Mr. Herman and Miss Powell are both here.
Thank you, Mary
Mr.
Ann.
Hermit can go
Welcome.
last. Mr. Herman, I'm just giving you a hard time.
I know you are, Judge. It's okay. I'm pretty thick-skinned. I'm used to it. There's 40 or 50 of you folks a month that take punches at me, so.
That was not a punch. If I wanted to punch you, I would just put you back in our waiting room.
No, there you go.
2148224 LT. This is Southport Apartments versus Shamaz Powell.
Richard Herman on behalf of Southport.
Powell,
Yes, Shamaz Powell.
state your name for me, please. Thank you so very much.
You're welcome.
This matters before the court this morning on the plaintiff's request to lift the SARA stay that went in place on November 24th, 2021. 77 days have passed since that stay has entered. Mr. Herman, what's the status of this matter?
Status is, Judge, that Ms. Powell owes $4,770. That's 4770 even with 154 in court costs. So the total redemptive amount getting her all the way through February is 4,924, 4924 even. I'd ask for a judgment. And
Wait,
it would-
Mr. Herman, hold
Pardon
on one
me?
second. What happened with the SARA application, Ms. Powell?
It's
Ms. Powell,
it still say it's submitted.
Can I ask a question of Ms. Powell, Judge?
Absolutely.
Ms. Powell, when did you last check on that application's status?
Today.
Okay. And when before that?
Almost every day before that.
Okay. Well, you're doing the right thing. You have to, the squeaky wheel gets the oil kind of thing. They're really jammed up, but it's been beyond 2017, which is the administrative rule that governs this. So Judge, I can do one of two things. I would like to see Ms. Powell get her money. I don't want to lose her as a tenant. On the other hand, it's getting to be a lot of days here. So what I'd like to do is take a judgment by consent, giving her till the end of the month, which is more time than the statute gives her. Or we can adjourn it for a week or so and get a status as to what's going on. I don't want to get my finger off the pulse too much on this one.
We cannot adjourn it for the week because the case is now with me. My next landlord tenant date is not until February 23rd.
Okay. So would the court consider giving me a judgment with a writ date of February 28th?
I'm sorry, March 23rd. Mr. Herman, I would do that. Ms. Powell, are you disputing that you owe $4,770 in rent?
No, that's correct.
Okay, ma'am, inasmuch as more than 45 days has passed since the stare stay was entered in this matter, the court is required on plaintiff's request to lift that administrative stay. Inasmuch as you don't dispute that you owe $4,770, the court will enter a judgment in that amount and include $154 in cost as requested by plaintiff's attorney. If Mr. Herman's client wishes to allow more than the statutory 10 days in that time for you to pay, that's up to him. He'll submit the judgment electronically to the court. I would suggest to you that as soon as you receive a copy of the judgment bearing my signature, you immediately contact Wayne Metro and let them know that is what happened, that a judgment has entered. That might get you might be the squeaky wheel that gets some movement on your application for funding, okay?
Okay.
Ms. Powell, because you're not represented by counsel, you'll have 3 business days to ask Judge Martin to set this aside if you have a good reason for doing so. And I was wondering, since you and I are in 2 different places, if I could sign your name to this.
Yes, that's fine.
Thank you.
Welcome.
Anything else, Mr. Herman?
No, Judge, that will do. Good luck, Ms. Powell. If you have any questions between now and then, please do not hesitate to call me. My name and number is all over your paperwork.
Okay, thank
Anything
you.
else, Ms. Powell?
No, ma'am.
Ma'am, we're all set. You may log off at this time.
Okay, thank you.
Who's here for Pallett's office?
Attorney Rochelle Concha, Your Honor.
Good morning, ma'am. This is 213862 LT. This is Rawsonville Woods versus David Lundy. David Lundy. Today is the day and time set for a hearing on plaintiff's request to lift the administrative stay that was put in place on September 29, 2021, at which time the defendant had indicated that there had been a SARA application. 133 days have passed since that time. Ma'am, has your client received any indication that the application has either been approved or denied?
I spoke to my client this morning, and since the time of filing, there has been no update as to the SARA application.
Inasmuch as this matter was scheduled at 9 o'clock, it's now 9:20 by the court's clock. More than 45 days have passed. Plaintiff has not received any decision from SARA, from Wayne Metro regarding this matter. That stay will be lifted. And ma'am, rent to retain possession?
$6,787.58. Court cost of $164 for a total of $6,951.58.
Defendant having failed to appear, Sarah stay lifted. Plaintiff may submit a default judgment that has $6,787.58 in rent, $164 in costs, for a total of $6,951.58. Ma'am, if you need the email address for the civil department, it is in the chat as of now. This is 213878 LT. This is Rawsonville Woods versus Dale Pettigrew. I have your appearance noted for the record. Today is a day and time set for hearing on the plaintiff's request to lift the Sarah stay that was put in place on September 29, 2021. 133 days have passed since that Sarah stay was put in place. Is Dale Pettigrew present in the courtroom? Inasmuch as this matter was scheduled for 9 a.m. and it's now 9:21 a.m. by the court's clock, defendant having failed to appear. Ma'am, has your client received any update on the Sarah application?
I did speak to my client this morning. They did inform me that the water bill was paid. However, nothing has been received since the time of filing. And then we would like to seek a default judgment in this case as well.
Rent to retain possession?
$6,150.81. Court costs of $164 for a total of $6,314.81.
Defendant having failed to appear, Sarah stay is lifted. Rent to retain possession is $6,150.81. Court costs $164 for a total of $6,314.81. Plan to submit that default judgment. Anything else in this matter, ma'am?
No, thank you, Your Honor.
This is 214040 LT. This is Swan Creek MHC versus Keisha Ori. Keisha Ori. Ma'am, your appearance is noted for the record. This matter is before the court this morning on the plaintiff's request to lift the Sarah stay that went into place on October 13, 2021. 118 days have passed since the entry of that stay. This matter was scheduled for 9 o'clock. It's now 9:23 a.m. No one has responded to the call of the defendant's name in this matter.
I am,
Ma'am,
ma'am, I'm here. I'm sorry. I
Miss
was
Ori.
here at 8:50. Sorry.
That's okay. Miss
Yeah.
Ori, what's the status of your Sarah application?
Unfortunately, it was denied 2 weeks ago.
So Ms. Ori, how are we proceeding with the unpaid rent in this matter?
I did pull out funds for my 401k, but it was only for the amount of $5,490. They would
Miss
not
Ori?
accept that amount. I'm sorry. Yes.
I was gonna say, I'm sorry, I'm gonna stop you for one moment. I'm gonna
Yes,
have you
ma'am.
talk to the plaintiff's attorney about this, okay?
Yes, ma'am.
Thank you. You're gonna see an invitation to join her in the breakout room. Please go there with her. When you come out, we'll get the case recalled, okay?
Your Honor, could
Thank
you
you.
also add my property manager, Jerry Daniel Swan Creek with me as well?
Absolutely.
Thank you.
Thank you. 214744 LT. This is Parks of Belleville versus Rachel Roberson.
Ryan Woodjick, P 84535 on behalf of the plaintiff.
Rachel Roberson. Today is a day and time set for hearing on plans request to lift the Sarah stay that went into place on November 10, 2021. 91 days have passed since entry of that stay. Sir, how are we proceeding in this matter?
Your Honor, we are requesting a default judgment at this time. The terms of which would be rent to retain possession of $5,469, cost in the amount of $164, for a total retained possession of $5,633, with a pay or move out date of February 21st, 2022. Partial payment will not prevent an order of eviction, and there is no money judgment at this time.
Thank you. This matter was scheduled at 9 o'clock. It's now 9:25 a.m. by the court's clock. Defendant having failed to appear, Sarah stay having been lifted. Default judgment shall enter in favor of plaintiff and against defendant. Rent to retain $5,469. Court costs $164. Partial payment will not stop a writ. Plaintiff to submit judgment.
Yes, I will
Anything
email
else in
that.
this matter, sir?
No, thank you, Your Honor. That clears up my docket. Have a great day.
Thank you, sir. Have a good day. Mr. Herman. 214827 LT, this is,
Judge, Mr. Herman's in a breakout room.
I see, thank you, ma'am. Ms. Zanin. This is 215638 LT. This is Mid Apartments LLC versus Nadira Muhammad. Uh-oh. Did we lose Ms. Zanin? Ms. Zanin. I see her here. Maybe she's in another courtroom, Marianne. I will pass that matter for a second. Mr. Robinson, have you had a chance to contact your client regarding?
Brookdale, Judge.
Yeah, I'm looking for the file now, sir. Two 20050 LT Brookdale Farms versus Gailey Irvin.
Morning, Your Honor, for the
Today
record.
is-
Oh, sorry.
Go ahead.
Good morning, Your Honor. For the record, Steve Robinson appearing on behalf of Brookdale Farms.
Thank you, Mr. Robinson. Today is a day and time set for the second hearing in this matter. First hearing was on February 2nd, 2022, which time the defendant failed to appear. Matter was scheduled for 9 o'clock this morning. It's now 9:27 a.m. by the court's clock. Gailey Irvin, defendant having failed to appear. Mr. Robinson, how you wish to proceed?
Your Honor, we move for entry of default judgment, rent to retain possession, excuse me, $1,544, cost in the amount of $164, for a total of $1,709.
Oh,
I'm sorry.
That's not, wait,
Oh,
1544 and 164?
correct.
1709.
No, both those numbers end in 4. 4 and 4 is never going to equal 9. Did I miss a number somewhere?
1545 rent.
5, thank you. That's me, Mr. Robinson.
Oh, okay.
Thank you. Sorry about that. Defendant having failed to appear, default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $1,545, cost of $164. Plaintiff to submit that default judgment to the court. Anything else in this matter, Mr. Robinson?
Not in this matter, no, Judge.
Thank you, sir. Ms. Zanin,
Good morning, Judge.
this is 215638 LT Mid Apartments versus Nadira Mohammed.
Good morning, Your Honor. Carrie Zanin, P67390 on behalf of plaintiff. I do apologize for the last hearing
No,
that
life
I
happens.
did
I
miss.
understand you were somewhere else. No. This matter was scheduled this morning on plaintiff's request to set aside the dismissal that entered on January 5th, 2022, when neither party appeared. Plaintiff's motion also requested that there be immediate hearing on this matter as well. Matter was scheduled for 9 o'clock. It is now 9:29 by the court's clock. Nadira Mohammed. Defendant having failed to appear, ma'am, how do you wish to proceed?
Plaintiff requests a default, first plaintiff requests that you grant my motion to set aside the dismissal, and plaintiff also requests a default judgment to be entered at this time. And I can give you the amounts owed, Judge.
Plaintiff's motion to set aside the dismissal is granted. Immediate hearing, which the defendant received notice of and failed to appear this morning. Default judgment will enter in favor of plaintiff and against defendant. Ma'am, rent to retain is
$4,650, court costs of $160, total rent retained $4,810, asking for a writ to issue date of, I think it's the 22nd because of the holiday, Judge, February 22nd, 2022.
Thank you, ma'am. Default judgment with rent to retain of $4,650. Court cost of $160 for a total judgment, $4,810. Writ date of 2/22/22. Plan to submit that default judgment. Anything else in this matter, Ms. Annan?
No, Your Honor. Thank you so much for your time. I appreciate you.
You're so very welcome, ma'am. You have a wonderful day. Thank you.
You too.
The parties are back on Ori.
Yes, Your Honor. I did
Ms.
have an
Lori?
opportunity. Oh, I don't know if she's back yet.
Yep,
Wait
I'm
one
here.
second.
Thank-
Okay, perfect.
Yep,
I
I'm
did
here.
have an
Thank
Lori,
you.
would you turn your video on for me, please?
Oh, I'm sorry. I'm in the car at my dentist's office waiting to go in. I'm so sorry.
Ma'am, you were saying you've had an opportunity to speak to Ms.
Yes,
Lori
speaking
and the
her-
parties have decided to.
We're entering a judgment today, which would give her the statutory time to make payment. If payment is made within the statutory time, then we would not seek the order of eviction.
Ms. Ori, is that accurate?
Yes, ma'am.
How much is the rent to retain?
$6,813.18. Court cost of $164 for a total of $6,977.18.
Ms. Ori, you were able to hear the attorney just now,
Yes, ma'am.
and you admit that there's rent due and owing of $6,813.18.
Yes, ma'am.
And plaintiff's attorney is requesting $164 in costs. That would be a total judgment of $6,977.18.
That is correct.
And in the breakout room, did you discuss submitting the judgment as a consent judgment, or?
I can submit that as a consent judgment, Your Honor. I would just ask if for the tenant's permission to sign her name to the agreement.
Yes, we've verified the amount multiple times. I wanted to make sure that when I did the cashier check for the additional amount that's owed, that I had the correct balance. That was all.
And that correct balance is the $6,977.18.
Yes, and they did agree to accepting 2 cashier checks. I do have a cashier check for $5,490 as of today. So I can do 2 cashier checks for the additional amount that was stated.
And ma'am, are you allowing more than the statutory time for her to make that payment?
We are not, Your Honor.
Plan to submit that consent judgment with the defendant's consent. Anything else in this matter on behalf of Swan Creek?
Nothing further, Your Honor.
Anything else, Ms. Ori?
No, I thank you for your time.
You're so welcome, man. Thank you for being on time this morning. You have a wonderful day.
Thank you, ma'am.
And then, Your Honor,
4827 LT.
sorry, I would just like to say that Ian Morton is here for he's going to appear on the Barry Stiers case. I'm not going to be handling that one. I just wanted to bring that to your attention.
Thank you, ma'am. 214827 LT, Southport Apartments versus Tanya DeGraffenreid. Reed.
Richard Herman on behalf of the plaintiff.
Excuse me, Danette McLemore here on behalf of the defendant, Tanya DeGraffenreid.
Judge, we've had an opportunity to discuss this in a breakout room. Apparently the defendant has filed for Sarah on 131. We would like, and I think it was approved. Did you not say that, Ms. McLemore?
It was approved on March 31st. She actually applied back in October, November, but.
Okay, so Judge, we would like just a very short adjournment so that we can keep our finger on the pulse, waiting to get paid.
Mr. Herman, my next landlord tenant date is March the 23rd.
Okay, so I don't have a
You put
problem
this
doing.
matter on-
Yeah, I don't have a problem doing that because I trust that this money will be here before then, and then Ms. McLemore and I can dismiss this matter.
Thank you.
We're going to adjourn this matter until March the 23rd, 2022 at 9 a.m. And if the parties are able to negotiate and execute a conditional dismissal, consent judgment, or whatever else in the interim, they can submit that to the court and won't need to appear on the 23rd.
Perfect. Thanks, Judge.
Anything else, Mr. Herman?
Nope.
Thank you, Your Honor.
Anything else, Ms. McLemore?
No, Your Honor, thank you.
Thank you so very much. You both have a wonderful day.
Great.
Thank
I have
you.
one more, if you don't mind, Judge. It was scheduled for 9, I think.
I'm going, Mr. Herman. I'm going straight down.
Okay.
This is 214-829 LT. This is Southport Apartments versus Keena Lawrence.
That's correct, Judge.
Convener
Richard Herman on
Lawrence,
behalf
I'm
of the
here.
plaintiff.
Lawrence, state your name for the record, please.
Convener Lawrence.
Today is the day and time set for hearing on the plaintiff's request to lift the Sarah stay that was put in place back on November 24th, 2021. We are showing Ms. McLemore as the attorney in this matter.
You know what? It's interesting because she asked me if there was an appearance, if she had filed an appearance, and I'm looking at the notice of hearing and there isn't one on here. So I don't really know.
Ms. McLemore filed an appearance in this matter back on November 23rd, 2021.
Have you?
Mr. Herman,
I was just wondering if Mr. Lawrence actually has had an opportunity to speak with her.
No, I haven't.
I didn't hear you, sir.
can't hear you, sir.
No, I haven't.
Have you filed for SERA funding, sir?
Yes, I have.
The Sarah stay has been in place since November 24th,
Oh, that's right.
2021.
That's right. I'm sorry.
Mr. Lawrence, have you received any update as to your Sarah application?
It's still submitted. It still says submitted on there.
Mr. Herman, would you be so kind as to give Ms. McLemore's office a call and get her back on if you can, please?
I don't, yes, except I don't, oh, yes, I do have a phone number.
You have a phone number? Okay. Mute yourself, sir. I'm going to go on to the next case that we have.
Judge, before you do that, I just want, before I forget, because these days I need notes to tell me where my notes are. I have 5 10 o'clock first hearings at 10 o'clock that I will not be handling. Mr. Joe Joseph will for me.
There are no first hearings with me.
You know what?
First
You're
hearings are on a
100%
different,
correct. Yeah,
first hearings are on a different Zoom number, sir.
yeah, it's a different
They're
Zoom
with my
number. I
resolve.
apologize. My mistake. Thank
Okay.
you.
Thank you. This is 220204 LT. This is Conditional Properties versus Janet Nagy. May I have your appearances, please?
Your Honor, Paul Janovich on behalf of the plaintiff, Conditional Properties.
Sir, my apologies. I saw you sitting there early on. I realized you only had one and you're sitting through the rest of me reading other people's cases. I am so extremely sorry for that.
Not a problem, Judge.
Janet Nagy.
You don't remember him?
Today is the day and time set for the second hearing in this matter. First hearing was on February 2nd, 2022, at which time the defendant failed to appear. This matter today was scheduled at 9 o'clock. It's now 9:40 a.m. by the court's clock. The defendant has again failed to appear. How are we proceeding this morning, sir?
We would like to have entry of a default judgment, Judge.
Rent to retain, sir?
The total would be $3,763, which is the original amount of the complaint, $2,646, February rent, late fee, and $160 in court costs.
So $3,603 in rent, $160 in court costs for a total of $3,763.
That is correct.
Plaintiff's office to submit as a default judgment. Anything else in this matter, sir?
No, Your Honor, thank you.
Thank you, sir.
We will submit the judgment.
Much appreciated. You have a wonderful day.
Thank you, you as well.
Thank you. Mr. Herman, any luck with Ms. McLemore?
Trying to still get through this.
Do you have somewhere
Woody.
else to be?
I'm sorry. I'm just trying to get through that.
Okay, that's fine.
Calling Lake Shirley
She's,
You've reached Danette McLemore.
she's not
Please
there.
leave a detailed message including your name, phone number, and case number if you know it, and I will be sure to give you a call back. Thank you. Have a great day. Please leave your message after the tone. When done, hang up or press the pound key.
Mr. Herman, are you supposed to be somewhere else this morning?
Danette, Richard Herman, please give me a call, 248. Well, you've got my number on your phone. Give me a call because you did file an appearance in DeGraff and Reed, and the judge is hoping that you'll call me back so we can take care of this. Thank you. I'm sorry, Judge.
My question to you is, do you have somewhere else you're supposed to be this morning?
10 o'clock.
10 o'clock. Give me a couple minutes. And
Yep.
hopefully she'll call us back.
Okay, thank you.
Thank you, sir.
Oh.
This is 220144 LT. This is GII 9 Harbor Club versus Dakota Meadows.
Attorney Rochelle Conja appearing on behalf of the plaintiff.
Thank you. Dakota Meadows. Today is the day and time set for the second hearing in this matter. The first hearing was on February 2nd, 2022, at which time the defendant failed to appear. The clerks adjourned this matter to today at 9 o'clock. It is now 9:43 a.m. by the court's clock. Dakota Meadows, defendant has failed to appear. Ma'am, how are we proceeding this morning?
We would be seeking a default possession only judgment with rent to retain of $2,570, court costs of $167 for a total of $2,737 even. Thank you.
Thank you. Matter having been scheduled for 9 o'clock, defendant having failed to appear by 9:43 a.m., default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $2,570, court costs of $167 for a total of $2,737. Plaintiff's office to submit that default judgment. Anything else in this matter, ma'am?
Thank you.
This is 220146 LT. This is GI&I 9 Harbor Club Apartments versus Devon Payne. Devon Payne. Wait a minute, just give me a moment, ma'am.
Okay.
Ma'am,
Okay,
that
so
you
go ahead,
joined us?
take this, go hang out until they
Hello?
call your name.
Hello?
If you have any questions, let me know. It's pretty straightforward. All they're
Hello?
gonna do is, right, they're
To
gonna
the
call your
person-
name. And
to
then
the
you're
person
gonna
that
say,
just
yes,
joined the
I
courtroom.
am.
Hello,
Sarah
the
number,
person
and then
that
they'll give
just
you an
joined the
automatic stay
courtroom.
while we wait for it, okay?
Okay.
So just be sure you give that to them and stay on
Hello?
there until they call your name.
Hello,
She's saying hello.
to the person that just joined the courtroom.
I'm trying to see because I don't know how to.
No, you don't need to see. You need to state your name for me, please.
Dakota Meadows.
Miss Meadows, your
Yes.
case was just called. Hold on one second.
It's okay. Let me shut that.
Ms. Meadows,
Yes.
your court case was scheduled at 9 o'clock. You failed to appear by 9:43.
I was having problems with my phone. I was trying to log in. It wasn't letting me log in.
Ma'am, have you made an application for financial assistance to paying the past due rent?
Yes, ma'am. My SARA number is 464041.
And when did you make that application?
Give me 1 second.
Approximately, I don't need the exact date.
Just tell her about a month ago.
A month ago,
On 12/6. So it's
on the 26th,
12, December 6th.
December 6th.
Have you given that information to your landlord that you could
Yes,
apply
ma'am.
for Sarah?
Yes, ma'am.
When the matter was called at 9:43 a.m., this is 220144 LT, the court granted the plaintiff's request for entry of default judgment. That, of course, is being withdrawn based on the fact that the defendant has appeared untimely, but has appeared this morning. Inasmuch as the defendant has indicated that a SARA application has been made, the court is required by Administrative Order 2020-17 to put a SARA stay in place. Ms. Meadows, the next thing that'll happen is in this matter is that you will receive a copy of the notice of the stay from the court. If within 45 days plaintiff has not received information that your application has been approved, denied, or they have received funding, they may petition the court to lift the stay and proceed to hearing on this matter. Understood?
Yes.
Anything else on behalf of plaintiff?
Nothing further, Your Honor.
Anything else, Ms. Meadows?
No.
Ms. Meadows, we're all set. You may log off. Thank you.
You're welcome.
So you got a 45 days.
220146 LTGI&I versus Devon Payne.
Your Honor, this one was actually a dismissal. I can resubmit it to the court if it hasn't been received.
I did not receive a dismissal this morning, but ma'am, if you send it over, civil clerks will match it up to the file and get it up to me for signature. Is there anything else in this matter?
Nothing further. Thank you.
Make a notation.
With oh, we're on there. Hold on.
This is 220148 LT. This is GI&I versus John Phillips.
Your Honor, this one's actually another dismissal. I can have my office resubmit the dismissal for this one as well.
Do you know when the original dismissals were submitted?
I believe it was on Monday, but I can recheck with my staff, and if it wasn't, I can have them resubmit it.
Thank you. I hate to do double paperwork, but when they get emailed over, sometimes it doesn't come right upstairs. I know they're a little short downstairs. I'll make a notation in the file, though, that a dismissal will be coming in this matter. There is a person with blinds and a valance, a white valance with some design along the edge of it. Yes, sir, with the cap on. Your name, please.
Talking to
Oh,
me,
I'm sorry.
ma'am?
Yes, I'm sorry.
My name is
Your
Shelda
name.
Hyder. I'm with Shelda Hyder
Here on the stage.
here on Estates.
Thank you.
And my husband's here with me. He's also Paul Hyder. We're married.
Thank you, ma'am.
Your Honor, that is one of my cases. I haven't had the opportunity to talk to that resident. Is it possible to be placed in a breakout room, please?
Absolutely, Marianne. I'll get you moved into a breakout room.
Thank you.
Thank you. This is
Hi.
22022. 220227 LT. This is Bell Creek Village versus Barry Steers.
Your Honor, for the record, Attorney Ian Morton of Pallets Law on behalf of Bell Creek.
Mr. Stiers?
Yeah.
Today is the day and time set for second hearing on the plaintiff's health hazard or injury to premises complaint. Mr. Stiers is actually downstairs in the courthouse. Mr. Morton, do you need to speak to him?
Yes, Your Honor. The first question would be, I know Mr. Stiers was speaking with legal aid to see if they were going to represent him. I've not received an appearance. Mr. Stiers can answer that question first, and then after that, I'm more than willing and would like to speak with him.
Okay.
Sir, have you retained legal aid, Lakeshore Legal Aid to represent you?
They sent me, my wife, email saying I wasn't eligible.
Okay, sir, you're going to see an invitation to go into a breakout room with Mr. Morton. Please join him there, okay?
I don't know how to do that.
Is there a court officer in there with you?
I'll go help him.
Okay.
Thank you so very much, Taylor. No luck, Mr. Herman?
No, I even tried to call back, Judge, and I got a more convoluted recording than I did the first time, so.
I'm not going to hold you, and I don't want to penalize Mr. Lawrence, who is here. This is 214829 LT. I want to look to see what we're doing on the 16th. It is not my landlord tenant day, but I don't want to have you wait a month. Mr. Lawrence?
Sorry, I don't know what.
Yes, I'm here.
Mr. Lawrence?
Yeah.
Lawrence?
Can you hear me?
Yes. What is the status of your Sarah application?
It still says submitted.
I can't hear you.
It still says submitted.
It's been submitted.
Yeah, that's all it says. It hasn't updated. It still says submitted on the application.
I'm not sure how you're speaking into the device you're using, but I can't hear you.
I was saying it still says submitted on the application.
Judge, if I may just chime in, why don't we just adjourn this to your next available date? And hopefully by then, the status will be something a little bit better than submitted. And if not, I'm going to ask for a judgment at that point.
The adjourn date is March 23rd, 2022 at 9 a.m.
Okay, that should be plenty of time. And if not, then.
Thank you, Mr. Herman.
Okay, thanks, Judge. I appreciate it. Have a great day.
Have a good day.
You as well.
Your Honor, this is Robert Cosby here on Estates. Would it be possible to be put into the breakout room with Ms. Scheid?
With Ms. Shy?
Yeah, Ms. Scheid and the Hiders.
Yes, yes. To the gentleman in the car?
Yes,
Your
ma'am.
name, sir?
Kevin Dale Zmerchek.
Thank you, sir.
Yes, ma'am.
Mr. Robinson, do you need to speak to him?
I do, Your Honor. And could you put
Mary Ann
Linda,
will-
could you put my client in also, Judge?
Ms. Thornsberry in with you and Mr. Zimser.
morning, Judge. Zmerchek.
Zimmercheck, thank you, sir. Ms. Shy, your client just wanted to go into the breakout room. What happened?
I Must have been just as I was exiting.
Good morning, Mr. Miller.
Good morning.
How are you, sir?
I'm good. How are you doing?
I am wonderful.
I see my colleague also in this Zoom gallery, but I think I'm taking over for her. I hope.
I'm still on from the 9 o'clock docket.
Oh, okay. I have 10 o'clocks. Got it. I will sit quietly.
Thank you, sir. This is 220149 LT. This is GI&I versus Natalie Rouse.
Attorney Rochelle Conja appearing on behalf of the plaintiff.
Thank you, ma'am. Today is the day and time set for the second hearing in this matter. Last name is Roose.
This is another
First
dismissal. Your
hearing
Honor.
was,
Sorry.
that's okay. You're saying this one is being dismissed as well?
Yeah, I'm gonna have my office resend the dismissals. That should be my last dismissal. The rest should be going. But yeah, that one is a dismissal as well.
Matter was scheduled at 9 o'clock. It's 9:57. Defendant hasn't appeared. Plaintiff is submitting a dismissal. Make a notation in the file. Get that over with the rest of your filings. I'd appreciate it. Thank you. This is 220151 LT. This is GI&I versus Demetrius Smith. Smith,
Yeah.
Demetrius Smith.
Oh, no. I have a question though. Excuse me. I'm sorry.
Yes, ma'am.
I just got out of a different Zoom with Zena May. I'm sorry, I don't know her last name, but it was Zena, and I was in the wrong one, and she directed me to this one. And I just want to make sure that I'm in the right spot because my rental office did not give me the
Yes,
proper
ma'am.
information.
We are 5 cases from calling your name. Okay.
Okay. Okay. I just wanted to make sure. Thank you.
No, you're perfectly fine. Thank you, ma'am.
Of course.
Demetrius Smith. This matter was scheduled for 9 o'clock as a second hearing. The defendant did appear last week on the 2/2/22 hearing. Now called the name 3 or 4 times, have not received a response. Matter was scheduled at 9 o'clock. It's now 9:58 a.m. How do you wish to proceed, ma'am?
Your Honor, we would be seeking a default judgment for possession only with rent to retain of $4,040, court costs of $167 for a total of $4,207.
Matter scheduled at 9 o'clock. Defendant failed to appear as of 9:58 a.m. Default judgment will enter in favor of plaintiff and against defendant with rent to retain of $4,040, court cost of $167, total of $4,207. Plan to submit that default judgment to the court. Anything else in this matter, ma'am?
Nothing further. Thank you.
Thank you. This is 220152 LT. This is GI&I versus Diamond Bessie. Diamond Bessie. Today is the day, ma'am, I've noted your appearance. Today is the day and time set for the second hearing in this matter. Defendant did appear at the first hearing on February 2nd, 2022. This second hearing was scheduled at 9 o'clock. It's now 9:59 a.m. by the court's clock. Diamond
Good
Bessie.
morning, Your Honor. Can you hear me?
Good morning, ma'am. I can hear you. Yes, ma'am.
Okay.
Ma'am, would you like to speak to Ms. Bessie and then to Ms. Smith?
That would be great. Yeah.
Marianne will put you in with Ms. Bessie first, and we're
That would
done
be
with
great.
her, again with Ms. Smith. Thank you.
Thank you.
This is 220179 LT, Huron Estates versus Kermit Patton.
Good morning, Your Honor. Jenny Scheid on behalf of the plaintiff.
Patton. Thank you. Today is a day and time set for the second hearing in this matter. First hearing was on February 2nd, 2022, which time the defendant failed to appear. This hearing was scheduled for 9:00 a.m. It's now 10:01 a.m. by the court's clock. Patent due. Defendant having failed to appear, ma'am, how do you wish to proceed?
Your Honor, we will request that a default judgment be entered for failing to appear at today's hearing. There is rent to retain of $1,581.92, court costs of $164.53, bringing the total to $1,746.45. This is for him to pay or vacate by February 22nd, and this is for possession only.
Thank you. Matter scheduled at 9:00, it being 10:01 by the court's clock. Defendant having failed to appear, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $1,581.92. There's $164.53 in court costs for a total of $1,746.45. Plaintiff's office will submit that default judgment to the court for entry. This is 220182 LT. Huron Estates versus Torrey Coleman and Felicity Title. This court did receive a dismissal this morning, and this matter has signed the dismissal.
Thank you, Your Honor.
220185 LT, Huron Estates versus Amy Gross and Christine Gross.
Again, good morning, Your Honor. Jenny Schneider on behalf of the plaintiff.
Today is the day and time set for the second hearing in this matter. First hearing was on February 2nd, 2022, at which time the defendants failed to appear. The court clerks adjourned the matter for 1 week. Notice was mailed to the defendants as of 10:03 this morning. Amy Gross.
She is here, Your Honor. I spoke with her in a
Unmute
breakout
yourself,
room.
Ms. Gross, and state your name for the record.
She did indicate earlier that this is her first time using Zoom. If she tapped her.
Oh, I tapped it. I'm so sorry.
Ma'am, you're okay. That's fine. I know the parties have had an opportunity to speak this morning. How are we proceeding?
Your Honor, I did receive information from Ms. Gross indicating that she has applied for a SARA recertification. Her application number is 221406-recert-1. As a result of her application, we are suggesting that a 45-day stay be applied.
Ms. Gross, inasmuch as you've made an application for a SARA recertification, this court is required by administrative order to stay these proceedings. The next thing that will happen is that you will receive a notice of that stay from the court. If for some reason within 45 days plaintiff has not received information that your application's been approved or denied or received funding in this matter, they may ask the court to lift the stay and proceed to hearing on this matter, okay?
Okay.
Anything else on behalf of the plaintiff?
No, Your Honor.
Anything else, Ms. Gross?
No, Your Honor.
Ma'am, we're all set. You can log off now.
All right, thank you. Have a nice day.
Thank you, Mr. Robinson. This is, what happened to Mr.? This is 220186 LT Huron Estates versus Sherry Gutnison and David Gutnison.
Morning again, Your Honor. Jenny Schneider on behalf of the plaintiff.
Today is the day and time set for the second hearing in this matter. The first hearing was on February 2nd, 2022, at which time both defendants failed to appear. The court clerks adjourned this matter for 1 week. Last name Gudnason. No one is responding to that. There are no unidentified persons in the courts virtual waiting room. Defendants having failed to appear. The matter is scheduled at 10 o'clock. It's now, I'm sorry, at 9 o'clock. It's now 10:06 a.m. by the court's clock. Ma'am, how do you wish to proceed?
Your Honor, we are requesting a default judgment be entered against the defendants for failing to appear at today's hearing. There is rent to retain of $1,472.11. There is also court costs of $199.06, bringing the total to $1,671.17. This is for the defendants to pay or vacate by February 22nd, 2022, and this is for possession only.
Defendants having failed to appear, default judgment shall enter in favor of plaintiffs and against defendant. Rent to retain $1,472.11, cost of $199.06, for a total judgment of $1,671.17. Writ date of February 22nd, 2022. Plaintiff's office to submit the judgment. Anything else in this matter, ma'am?
Your Honor.
Thank you. This is 220187 LT Huron Estates versus Paul Hyder and Sheeta Hyder.
Shelda Hyder, ma'am.
Good morning again, Your
Sheldon,
Honor.
sorry.
Jenny Scheid on behalf of the plaintiff.
Hello.
Hyder, please state your name for the record.
Shelda Hyder and Paul Hyder.
Is Mr. Hyder there with you?
Yes, ma'am. Here,
I'm right
he's right
here.
here. He's disabled, ma'am. Right here.
Thank
Hi.
you, ma'am. Hi, today is the day and time set for the second hearing of this matter. The first hearing was last week, February 2nd, 2022, at which time the Hyders failed to appear. Ms. Scheid, if you had the opportunity to speak with them,
I have, Your Honor.
how are
They
we
have a-
proceeding this morning?
They have applied for SERA assistance, and it is my information from them, and Mr. Koss can confirm hopefully that the application has been approved for SERA and would be enough to cover the current balance. As a result, we will be drafting a conditional dismissal to file with the court to finalize this court case.
That is correct.
How long do you think it will take you to get that submitted?
Less than a week, Your Honor. I've already spoken with Ms. Hyder. I will draft it and send it to the office for them to make arrangements with the Hyders to come in and sign it.
Thank you. I'll make an indication in the file that that is what the parties will be doing, submitting a conditional dismissal to the court. If for some reason the court clerks don't receive it within the next 2 to 3 weeks, you might get a notice reminder to get something submitted. But we'll consider the matter resolved, okay?
Thank you, Your Honor.
Anything
Thank
else on behalf of Huron Estates?
Not on that case, Your Honor.
Anything else from the Hyders?
No, ma'am. Thank you.
Thank you. Have a good day, ma'am.
You too.
You too. ma'am.
This is 220188 LT Huron Estates versus Richard Kirk and Marissa Villa.
Jenny Scheid on behalf of the plaintiff.
Richard Kirk, Marissa Villa. Today is the day and time set for the second hearing in this matter. First hearing was on February 2nd, 2022, at which time both parties did appear. Ma'am, how are we proceeding this morning?
Your Honor, we had entered into a verbal agreement that the Mr. Kirk and Ms. Vella would pay the remaining balance by February 11th. I had drafted a conditional dismissal to this effect and emailed it to Mr. Kirk. Unfortunately, we have not received that signed document back. So at this point, we do not have an agreement with that.
This matter was scheduled at 9 a.m. It's 10:09 by the court's clock. Defendants having failed to appear, ma'am.
Your Honor, we would proceed with a default judgment at this point, and if they do in fact pay the difference by February 11th, like they had originally planned to, then we will not execute for a writ of eviction.
The rent to retain possession?
Yes, so the rent to retain is $1,414.62. There's also court costs of $199.06. bringing the total to $1,613.68. This is for them to pay or vacate by February 22nd, 2022. And again, this is for possession only. And again, if they do pay it, in the meantime, we will not request the writ.
Thank you. And as much as the defendants have failed to appear as directed by this court, default judgment will enter in favor of plaintiff and against defendants with rent to retain possession of $1,414.62. There's court cost of $199.06 for a total judgment of $1,613.68 for date of February 22nd, 2022. Plaintiff's office to submit that judgment to the court for entry. Anything else in this matter, ma'am?
No, Your Honor. And I believe that concludes the Huron Estates cases, and my colleague, Mr. Miller, will take over for all of our remaining clients.
Thank you, ma'am. Have a good day.
Thank you. You too.
Thank you.
This is 220216 LT. This is Royal Village versus Kevin Zamirzak.
Good morning again. For the record, Your Honor, Steve Robinson appearing on behalf of Royal Village. Your Honor, I've had an opportunity to speak to Mr. Zamarchek, sorry about that. And if with the court's indulgence, if we could get an adjournment to your next landlord tenant docket, Judge, to give Mr. Zamarchek an opportunity to take care of some issues, that would be greatly appreciated.
Sir, is that what you wish to do?
Yes, ma'am, please.
This matter will be adjourned to March 23rd, 2022 at 10 a.m. Anything else on behalf of the plaintiff?
What was that date again, Judge? Judge, what was that date again?
March the 23rd
March 23rd. Thank you. Sorry, I didn't hear it.
at 10 a.m. Anything else on behalf of the defendant?
No, ma'am.
No, thank you, sir. We're all set. You may log off.
Thank you, ma'am.
Thank you,
Back
Judge.
on the record in 22.
I'm all done with you this morning. Thank you.
Good to see you, Mr. Robinson. Have a good day.
Same here, Judge. Take care.
Back on the record in 220227 LT, Bell Creek versus Stiers.
Good afternoon, Your Honor. Attorney Ian Morton of Pallets Law on behalf of Bell Creek. I did have a chance to speak with Mr. Stiers and we have come to a resolution.
And that would be?
Your Honor, the terms of the agreement are as follows. We've agreed to enter into a proposed consent judgment. We've agreed to extend the time period before the order of eviction can be entered for 30 days. Therefore, it's going to be extended to March 11th, 2022. This will allow Mr. Stiers to be able to vacate.
I'm sorry, Mr. Morton, stop for 1 second.
On the left side. We want to kind of separate those kind of things, right? Is there a misalignment at the first part? And it is not misaligned, and all the other parts do not have that together, right? So you have just one part, or all, like, is it one vote, or all the vote?
Stop this person for some reason. You have to. I'm sorry, Mr. Morton.
Understood, Your Honor.
You said extend the red date to March 11, 2022.
March 11, 2022, the parties agree that he intends to abandon his interest in the ownership of the mobile home, and further will confirm he is vacated by turning the keys over to the community. He's given me permission to sign his name and have also advised him his rights under MCR 4.201.
Mr. Stiers, were you able to hear Mr. Morton just now?
Yes, sir.
And it's your intention to to abandon your interest in the mobile home at Bell Creek Village?
Yes, ma'am.
And that will happen on or before March 11, 2022?
Yes.
And you've agreed that Mr. Morton may sign your name to a consent judgment with these terms?
Yes.
And Mr. Morton also explained to you that this judgment would not be in effect for 3 days in as much as this consent judgment and you're not represented by an attorney?
Yes.
Anything else, Mr. Morton?
No, Your Honor.
Anything else, Mr. Stiers?
No.
Thank you both for your patience this morning. We're all set. Mr. Stiers, you may log off or just leave that room and the court officers will take care of it for you, okay?
Thank you.
Thank you, Your Honor.
you. We passed this. I'm sorry. 220152 GI&I versus Diamond Vesey.
Rochelle Concha appearing on behalf of the plaintiff.
Hello.
There she is.
Ms. Vesey by Zoom. How are we proceeding this morning?
Your Honor, I had an opportunity to speak with the defendant, and she has applied for Sarah number 544149, and we would just ask that this be put into the Sarah stay.
Thank you. And as much as the defendant has made application for funding through the SARA program, this court is required by administrative order to enter a stay of these proceedings, and will do the same. Ms. Vesey, the next thing that'll happen in this matter is that you'll receive a copy of the court's notice that the matter has been stayed. If for some reason within the next 45 days, plaintiff has not received information that your SARA application has been approved or denied, or receive funding in this matter, plaintiff may petition the court to lift the administrative stay and proceed to hearing in this matter. Anything further on behalf of the plaintiff?
Nothing further, Your Honor.
Anything further, Ms. Vesey?
No, everything fine over here. Thank you.
Thank you, ma'am. You have a wonderful day.
You too. Bye.
Thank you. This is 220176 LT. This is Holiday West versus Deja Smith.
Attorney Rochelle Concha appearing on behalf of the plaintiff.
Hello,
Ms. Smith, state your name for the record.
Deja Smith.
Thank you. Today was the day and time set for the second hearing in this matter. The first hearing was on February 2nd, 2022, at which time the defendant failed to appear. Defendant did appear today, and the parties have had an opportunity to speak. How are we proceeding this morning?
Your Honor, same thing with this one. She did let me know she's applied for Sarah. Her Sarah number is 377426. She's communicated with her caseworker. Everything's been submitted. She's one step away from the approval stage. So we would just ask that this be put into the Sarah stay.
Thank you. Ms. Smith, inasmuch as you have submitted an application for funding through the SARA program, this court is required by Administrative Order 2020-17 to enter an administrative stay in this matter. We will do that. You'll receive a copy of that stay from the court. If for some reason within the next 45 days, plaintiff has not received an indication that your application's been approved, denied, or funding made in this matter, plaintiff may submit a request to the court to lift the administrative stay and schedule the matter for hearing. Anything further on behalf of plaintiff?
Nothing further, Your Honor.
Anything further on behalf of defendant?
No, there's not.
Ms. Smith, we're all set. You may log off. Have a wonderful day.
Thank you. Do the same.
Thank you. This is 220166 LT. This is Green Meadows Apartments versus Ebony Powell.
Attorney Rochelle Concha appearing on behalf of the plaintiff.
Powell. Today is the day and time set for the second hearing in this matter. First hearing was on February 2nd, 2022, at which time the defendant failed to appear. Notice was sent to Ebony Powell to appear this morning at 9 a.m. It is now 10:19 by the court's clock. There are no unidentified persons in the court's virtual courtroom. There's no one waiting in the court's virtual waiting room. Defendant having failed to appear, ma'am, how would you like to proceed?
Your Honor, we would be seeking a default possession only judgment with rent to retain of $3,367.27, court costs of $164, for a total of $3,531.27.
Thank you. Defendant having failed to appear, default judgment will enter in favor of plaintiff and against defendant with rent to retain $3,367.27, court cost of $164, for a total judgment of $3,531.27. Claim to submit the default judgment to the court for entry. Anything else in this matter, ma'am?
Nothing further. Thank you.
This is 220171 LT. This is Holiday West versus David Childs.
Attorney Rochelle Concha appearing on behalf of the plaintiff.
Today is
Yes.
for the second hearing in this matter. Both parties appeared last week on February 2nd. Both parties are here this morning. Mr. Childs, please state your name for the record.
David Childs.
Thank you. How are we proceeding this morning?
Your Honor, I know at the last hearing, he stated that he might recertify with Sarah. I don't have any indication that he has. I would just ask, Mr. Childs, have you recertified with Sarah?
Yes, I did. And the number is 176103-recert-1.
So, Your Honor, with that being said, we would put this into the Sarah stay.
Thank you. Inasmuch as defendant has indicated that he's made an application for Sarah recertification, this court is required to stay these proceedings. Mr. Childs, the next thing that will happen is that you'll receive a copy of the court's notice that the matter has in fact been stayed. If for some reason within the next 45 days, plaintiff has not received notice that your application's been approved, rejected, or received funding in this matter, they may petition the court to lift the stay and schedule this matter for hearing. Anything else on behalf of the plaintiff?
Nothing further. Thank you.
Anything else, Mr. Childs?
No, Your Honor.
We're all set, sir. You may have a good day and log off at this time.
Thank you. You as well.
Thank you. Two 22021 ALT Evergreen Town and Country versus Sarah Bingham. Mr. Robinson was here previously, indicated that there will be a dismissal submitted in this matter. File will go downstairs to wait for that to be submitted. 220223 LT. This is Walter Sikowski versus all occupants at 49066 Tagauti Pass, Belleville.
Moving out.
Good morning, Your Honor. Joe Horka, P75969, the attorney for the plaintiff.
Mr. Outlaw, hold on one second. What are you here for, Mr. Outlaw? Sir, you're muted. When you pull over, I'll call your name again. I want to know what you're here for, okay? Mr. Stanford, were you starting to say that you're here for this case?
Yes.
I'm unmuted. I'm unmuted. I didn't know how to unmute it.
Hold on, Mr. Outlaw, what are you here for?
Court.
Honey, I need something more specific than that. What kind of court? I'm sorry.
Gateway Townhome.
Judge, he's supposed
Marianne,
to
were
be
you
with
trying to help me?
Zena.
Mr. Outlaw, you are in the wrong courtroom.
On my paperwork, it say your name.
It says my name, but not my number. You're supposed to be in with Zena. What I would suggest you do, when you get somewhere where you can stop driving, not be smoking, not have a hat on, you can try to log on somewhere else, okay? You're in the wrong courtroom. Get your notice and log into the right courtroom, okay?
Her name's Zena?
Yes.
Okay. Thank you, ma'am.
Thank you. Have a good day. Mr. Stanford, my apologies. I see your note that you need to get to work soon
Yes.
and that you will be represented. What is your attorney's name?
Arthur Brandt. And matter of fact, I was supposed to go see him at 10 o'clock right now, but y'all ain't called me until 10:24.
Judge, I'm kind of confused if you're supposed to meet him at 10 o'clock, why he's not present here to represent him or filing an appearance.
Because I was supposed to talk to him today about my court date today, but he's been very busy since he been backed up with the snow and stuff like that.
Mr. Stanford, turn your video on for me, please, sir. Thank you. This court has not received any appearance from the defendant. I'm sorry, on behalf of the defendant in this matter. Mr. Stanford, are you the only occupant there at the property?
No, me and my sister.
Have you actually retained Mr. Grant?
Mr. Grant, you talking to me?
Yes. Have you actually retained the attorney, sir?
I'm confused what you mean. Like, have I gotten an attorney? That's what you're asking me?
Correct. Yes, sir.
Oh, yes, yes. Well,
But he
I'm
could
supposed to go.
not-
Well, I'm supposed to go talk to him as we speaking right now to see if he was going to take this case or not. The only reason why I couldn't get him earlier because this case was abruptly put on me like a week ago, and when I tried to contact him, it was snow. He was been busy. Blase, blase. That's why I was supposed to go meet him today.
This case was abruptly put on you?
Yes. Where the court
Okay.
case is. Yes.
I'm looking at it at a notice to quit date of September 23rd, 2021. The plaintiff filed this case on January 20th, 2022. Certified mail was sent to you, well, sent to the property on January 28th, 2022. There was personal service made on this matter on January 29th, 2022. Mr. Horka.
Judge, this is a complaint to recover possession. My client has letters of authority to proceed on behalf of the estate. He's asking for possession of the unit. At the mediation, Mr. Stanford appeared and indicated he had filed some kind of petition to remove Mr. Sikowski.
Yes.
I asked for him to send me a copy of that petition and send my client a copy of that petition or serve him properly. And to my knowledge, neither of those things took place. So
I sent it to his.
Mr. Stanford, please don't interrupt him.
I'm sorry.
I feel like we're kind of spinning our wheels and there's been no appearance filed. I'd ask for possession today.
Mr. Horka, the court is not inclined to do that at this time. I will make an indication in the file that Mr. Stanford has indicated that he is in the process of retaining an attorney. This court's next landlord-tenant date is March the 23rd, 2022 at 10 a.m. Mr. Stanford, if you do retain an attorney in this matter, they need to file an appearance and appear on that March 23rd date, or else the court will entertain Mr. Horka's request to recover the property.
Okay, yes, but with the petition going through, with whether it's go through or not, it would stop his Walter for being active rep, like regardless. Like if
So
I
Mr. Stanford, Mr. Stanford, hold on one second. You're talking about a petition that you filed in probate court, correct?
yes.
This is district court. So whatever fight that you're having with the personal rep in probate court, it does not negate what's happening here. Okay, not for right now.
Okay, so I'm saying like once the petition is filed, though, he won't be active rep no more. He won't be. He can't be active as rep, so he can't be pushing me out of the estate.
If when the parties come back on March the 23rd, 2022, there are some documents from a superior court that indicate that the plaintiff, as he appears, is not authorized to proceed in this matter. We'll address that on the 23rd, okay?
Okay.
Reasonable, Mr. Stanford?
Yes, you said March 23rd, same courtroom.
Same courtroom. You'll get a notice in the mail from the court clerk, okay?
Okay, thank you.
Thank you. Have a good day.
Judge, I would just
Thank you
renew
for
my
your patience,
request
Mr.
for Mr. Stanford to send me any written documentation he plans to rely upon at a hearing, including this petition that he indicates he's filed.
I
Do
sent
you
it
have
to.
Mr. Stanford's contact information?
Just the home address, Your Honor. I'd be happy to take anything else.
Marianne, listen, Marianne's gonna move you into a breakout room so you all can get good contact information and you can discuss specifically what it is that you want Mr. Stanford to send to you, okay?
Thank you so much, Your Honor.
Thank you, sir. Mr. Cronin. Uh-oh.
He's in a breakout room.
Something happened and I lost all of my ability to see anything. I must have lost my co-host status.
Let me put you back. That's weird.
No, it's been a weird morning. There were too many at 9 o'clock. We have to figure out a good balance. 30 an hour when people need to go in a breakout room. It sounds good, but it never works out. And I know that Mr. Katz is here and we're at 10:30, so I'm ready to call him if he's ready.
I do have one other
Everybody's in
person.
breakout rooms.
I haven't spoken to Miss Moore. It looks like she's one of mine.
I was expecting to see your face and I hear your disembodied voice. I saw you
How
with a
about that?
jacket and tie on when you first logged
I know,
on.
I said that was wrong
so
today.
surprised and happy.
I'm sorry about that. I know you look
No.
forward to
This is
Um,
214759 LT. This is Pinewood Circle versus Chantal Moore. May I have your appearances, please?
good morning, Your Honor. Sydney Katz on behalf of the plaintiff. I think I'm joining a breakout room to speak with Ms. Moore, possibly.
You need to speak to Ms. Moore?
Yes, I haven't had a chance, but I did speak to Ms. Clark already. So I don't know if you want to hear that one first or just put me in a breakout.
I am
or,
happy. Desiree Clark? Thank you. Ms. Clark?
I think she's at work, so we did enter into consent. Oh, there she is.
Okay, I'll see.
214750 LT. This is Pinewood Circle versus Desiree Clark.
Good morning, Your Honor. Sydney Katz on behalf of the plaintiff.
Ms. Clark, you state your name for me, please, ma'am.
Desiree Clark.
Thank you. Today is the day and time set for hearing on the plaintiff's request to lift the Sarah stay in this matter. The Sarah stay went in place on November 10th, 2021. That was 91 days ago. Ms. Clark, has your Sarah application been approved?
Yes, it has.
Has payment been made to your landlord?
No, she received notification that it was approved, but they have not received payment yet. I received
Mr.
payment.
Katz, how are we
My
proceeding this morning?
So, Your Honor, at this point, we did discuss this, and we have been having some problems as far as getting the agencies to move forward and get the money to my client. We did enter into consent, basically giving Ms. Clark until the 21st to just ensure that my client receives the funding. And this will hopefully put a little pressure under Wayne Metro to ensure that the funds are received. I have had some success with doing it this way. It's unfortunate that we have to go to this, measure to do that. But if she does need the judgments lifted at some point, I will provide a satisfaction of judgment if required at some future date.
The rent to retain, sir?
Oh, I'm sorry, Your Honor. But $5,722 with a writ date of February 21st.
Cost?
I'm sorry, that includes costs of $152. So
I'm
it would
sorry,
be,
Mr. Katz, you're muffled.
it's 5570 it's 5570 of rent, 152 of costs for a total of $5,722.
Ms. Clark, do you agree that the rent due in this matter is $5,570?
Yes.
And plaintiff has made a request for $152 in costs. That's a total of $5,722. The parties have discussed a consent judgment. Ms. Clark, have you authorized Mr. Katz to sign that consent judgment on your behalf?
Yes.
And Your Honor, I did advise her of MCR 4.201 as well.
Clark, Mr. Katz advised you that inasmuch as you're not represented by an attorney, that this consent judgment would not go into effect for 3 days.
I'm sorry, could you repeat that?
Did Mr. Katz advise you that inasmuch as you're not represented by an attorney, that this consent judgment would not go into effect for 3 days?
Yes.
Thank you. Mr. Katz, get that submitted to the court. I'd appreciate it. The writ date will be 2/22 because the 21st is a holiday, okay?
Oh, yep, perfect. Thank you. And if
Thank
I'm
you.
going to
Mary
join
Ann?
that breakout room number 2 with Ms. Moore.
Ms. Clark, we're all set, ma'am. You may log off, and Mr. Katz will go into a breakout room with Ms. Moore.
Thank you.
Mr. Miller, do you have a preference as to which case goes first?
I don't, Your Honor. I think I've resolved them all.
Oh, that
Wait,
sounds so wonderful. And so
Wait, did you sound disappointed? That's what I
I'm
heard.
not
I heard
disappointed.
disappointment.
No, because that means you've been working. We're running late because we had a heavier docket than usual for second
Well,
hearings.
we'll get you all caught up right now.
I appreciate you taking the time to get these things worked out. This is 214709 LT. This is West Village Estates versus Crystal Scott.
Good morning, Your Honor. My name is Matthew Miller. I'm here on behalf of the plaintiff, West Village Estates. I'm joined by the community manager, Renee Samples, on Zoom. Ms. Scott.
Good morning, Your Honor. My name is Crystal Scott.
Thank you, Ms. Scott. We're here today on the plan's request to lift the Sarah Stay that went into place on November 17, 2021. That was 84 days ago. What's the status of the matter, Mr.? What's the status of the matter, Mr. Miller?
Your Honor, in talking with Ms. Scott, what we've agreed to do today is to enter into a conditional dismissal that will provide her until February 28th, 2022 to pay the back rent of $5,897.96, cost of $164.53, for a total of $6,062.49. She has given me permission to sign her name to this conditional dismissal, which I will submit to the court today. And she is hoping to take that to Wayne Metro to try to get them to expedite her approval in this matter.
Ms. Scott, were you able to hear Mr. Miller just now?
Yes, I was.
And is it your understanding that there will be a conditional dismissal of this matter
Yes, I do.
where there is $5,897.96 in rent due owing and $164.53 in cost?
Yes.
And you've authorized Mr. Miller to sign your name to that conditional dismissal.
Yes, I did.
Do you have any questions, ma'am?
I think I've got it. So I take the conditional release and I give that information to Sarah, and then they proceed to pay. Is that how it's supposed to go after that?
Fingers crossed that once you have the conditional dismissal that the court has signed and you advise the Sarah people of that, now that we've been almost 3 months from the time you filed your application, that will kind of get the wheels going on getting the funding released to your landlord, okay?
Okay, thank you.
Anything
Thanks
else,
for
Ms. Scott?
explaining that. No, thank you for explaining that. I appreciate that.
You're so welcome, ma'am. Unless you have any other questions, you're all set. You may log off.
Okay, thank you very much. Have a good day.
You too, thank you. This is 214721 LT West Village Estates versus Raymond Cronin and Tracy Cronin.
Your Honor, again, for the record, my name is Matthew Miller. I'm here on behalf of the plaintiff, West Village Estates.
Hello, my name is Ray Cronin.
Mr. Cronin, where is Tracy Cronin?
Tracy doesn't live here anymore. We're separated. We're going through divorce.
Mr. Cronin, sorry to hear that. I'll make a notation to file. Mr. Miller, today was the day and time set for hearing on the plan's request to list the Sarah Stay that went into place on November 17th, 2021. 84 days have passed since entry of that stay. How are we proceeding this morning?
Same as before, Your Honor. I'm going to enter into a conditional dismissal with Mr. Cronin. The amount of rent due and owing is $3,381.17. Costs are $199.06 for a total of $3,580.23. Again, we're going to give him till the end of the month, February 28th. I guess we'll still dismiss the case conditionally against Tracy Cronin because it doesn't really do me any good one way or the other. But he's given me permission to sign his name to that conditional dismissal, and I'll submit it to the court for entry today.
Mr. Cronin, were you able to hear Mr. Miller just now?
Yes, I was, Your Honor.
Sir, inasmuch as you made an application for Sarah funding, more than 84 days have passed and the plaintiff has not received payment or indication that your application's been approved or denied, this court is going to lift the stay that's in place. The parties are entering into a conditional dismissal wherein there is $3,381.17 in rent due and owing, $199.06 in court costs, for a total of $3,580.23. The plaintiff has further indicated that you will have until February 28, 2022 to pay that amount. Mr. Miller also indicated that you've discussed and agreed that he will sign your name to the conditional dismissal. Was that your understanding, Mr. Cronin?
That's my understanding, correct?
Do you have any questions, sir?
No, Your Honor.
Anything else in this matter, Mr. Miller?
No, thank you, Your Honor. We'll get it to you today.
Thank you. Mr. Cronin, thank you for your patience this morning. Have a wonderful day, sir.
Thank you. You as well.
Thank you. 214726 LT. This is West Village Estates versus Marnique Gibbons and Kendra Boscom.
Yes, Your Honor. Good morning. My name is Matthew Miller, P51351, here on behalf of the plaintiff, West Village Estates.
Ms. Boscom,
Yes, ma'am. Good morning.
would you state your name and turn your video on for me, please?
Kendra Bascom and
Bascom, thank you. Is Marnique Gibbons present?
yes, he just stepped into the restroom.
Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay that went into place on November 10th, 2021. 91 days have passed since entry of that stay. Mr. Miller, how are we proceeding this morning?
Your Honor, very similarly to the last two, we're going to enter into a conditional dismissal with the defendants that there's now due and owing $5,992.26 in rent. We have costs of $164.53 for a total of $6,156.79. And again, we're giving until February 28th, 2022 for this to be caught up. I've spoken with Ms. Bascom, and she's given me permission to sign her name to the proposed conditional dismissal, and I hope that Mr. Gibbons would do the same.
Ms. Bascom, were you able to hear Mr. Miller just now?
Yes, ma'am.
I lost my lights there for a second. And ma'am, is it your agreement that $5,992.26 in rent is due and owing?
Yes.
The plaintiff has also made a request for $164.53 in costs, which will be a total conditional dismissal amount, $6,156.79, that the parties will submit in a conditional dismissal. Ms. Bascom, have you been in contact with the Sarah people?
Yes, after I got out of the breakout room with Mr. Miller, I called them and I spoke with them. I have been in contact with Sarah since I gotten approved. I just spoke with the gentleman and he looked into everything, and just like the other lady, the DTE was paid, but because West Village doesn't take the payments directly, we're waiting on it. And he said that he sees that it's past the deadline of when I was supposed to have received it. He's going to escalate it to the accounting team and have them reach out to me and see why I haven't received the funds to make sure I do receive the funds.
Okay. And it was your agreement that with Mr. Miller that he will sign your name to the conditional dismissal?
Oh, I thought that he told me to meet Renee in the office today to sign my name.
Well, I can do it either way, ma'am.
Wonderful.
Okay, I can meet with Renee, if that's okay with Renee, if she'll be there.
Mr. Gibbons would have to go as well.
Mr. Gibbons is here as well, and he is able to meet them as well.
Okay, I'll send it to Renee and you can come in and sign it today.
Okay.
Anything else in this matter, Mr. Miller?
No, thank you, Your Honor.
Any questions from you, ma'am?
No, ma'am.
Any questions from Mr. Gibbons?
No.
We're all set. Thank you so much for your patience this morning. You may log off at this time.
Thank
Thank you, Judge. Have a great day.
You too. Uh-oh. Marianne, it's not good when there are no people. And there's still 3 files left.
They're still in a breakout room though, you know that.
I see them now,
Okay.
yes. So what is a good number per hour is the question.
Not
We're
this.
off the rails this morning.
Yeah, not this. Why can't we do it like every 10 minutes? Would that just stretch it out too long?
There are 32 cases scheduled at 9 o'clock. I think if we did 20 at 9 o'clock and I go back until waiting till the end to take all of the defaults or whatever, that might be helpful. 31
Yeah.
is just, or 32 is just too many. And as soon as somebody goes into a breakout room and that attorney is the only attorney from that bunch of cases, everything else kind of lags.
Yep, that's what happens.
Not a problem, just continuing to adjust and pivot and try to accommodate people. I just feel bad when people are at work or having to wait. And it's taking us a while.
I like the way this guy, Mr. Miller, just did it. He would send me a chat, and as soon as he was done with one, he'd say, "Okay, can I please have this guy?" I mean, he was like on top of it. He was good.
I think part of it is being in practice for a long time. And now that we are almost 2 years in Zoom, people are being a little bit better about how they move and speak with each other in Zoom. And as soon as Miss Allen gets her video and her audio on, ma'am, I will call this case. This is 213386LT GINI versus Allen.
Attorney Rochelle Kanja appearing on behalf of the plaintiff.
Miss Allen, just state your name for me, please.
Hi, it's Kyla Allen.
Thank you. Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay. That stay went into place on September 1st, 2021. That was 161 days ago. What is the status of this matter?
Your Honor, I had an opportunity to speak to the tenant and my client while I was in the waiting room, and there was a $5,690 check that was issued. However, my client, for some reason, there was an issue with the check. We weren't able to read it. So eventually that will be cashed, but she still will have a remaining balance of $3,893. She did let me know she's recertified for Sarah. However, since this has already been 133 days, I would just ask for a 30-day adjournment. So hopefully between now and the next 30 days, her recertification part 2 can go through. That number is 134512-recert2. I would ask that this not be put into the Sarah stay as it's been 133 days since the first one.
Miss Allen, your response to that.
Yes, so I've been working with my caseworker. I was waiting on my Sarah funds for literally 6 months before they issued the check. I was approved for that. I did send the check over to my leasing office, who told me that they had to send the check to corporate because there was something wrong with the check system in the leasing office. And I did recertify. So after I sent that check, I have this remaining balance. I'm waiting on recertification. But if it does take that long again, then I'll just have to use like my taxes to get caught up.
When was that $5,690 check received?
January 7th, I picked it up from the Sarah offices downtown, and I turned it into my leasing office on January the 8th.
Here's the thing, and I guess this is kind of my concern. The recertification is actually a second request for funding. Why would that not also be subject to the stay requirement?
Your Honor, so with the first certification that she did have, this is a second recertification. I'm under the impression that since they didn't cover it the first time, the full amount, I'm not confident that they will cover the full amount this time as well. We're just hoping that we can get that 30-day adjournment if that's possible, instead of putting it into the 45-day stay, so that we have a certain hearing date, and hopefully that can help push this Sarah process along. And if they don't pay the full amount, then hopefully Ms. Allen would be able to cover the remaining balance that they don't cover.
No, I guess my more direct question is, when you received a payment of $5,600 a month ago, why didn't that trigger either a conditional dismissal or some other resolution of the balance?
It didn't pay the full balance. She owed around $9,500. It didn't pay the full balance.
I understand that, but what I'm saying is, if somebody owes you $9,000 and you receive $5,600, what do you do next? You do nothing until you make the request to lift the stay? Why wouldn't you do a conditional dismissal or a That's more me thinking out loud. I'm sorry to subject you to that. We'll adjourn this matter to March 23rd, 2022 at 10 a.m. I made a notification in the file that there is a Sarah recertification pending. Ms. Allen, you might want to follow up with the worker you've been in communication with regarding this matter. When we come back on the 23rd, we'll figure out if there is more funding available to you on this recertification, or if you have sufficient resources of your own to pay the remaining balance, okay?
Okay, thank you so much. I appreciate it.
Anything else on behalf of the plaintiff?
Nothing further, Your Honor. Thank you.
Anything else, Ms. Allen?
No, thank you both. You've been a great help.
Thank you for your patience, ma'am. You have a wonderful day. Conjure, we're just starting to see these recertifications, and when there is a payment between the first day and our next hearing, and then I know the intention is not to stay these matters indefinitely. It's just a matter of figuring out best way to proceed.
Right.
Is that it for you this morning?
I did have one more at 10 o'clock. It looks like for Trilogy. It was Jonathan Darby and Roshonda Wharton, 213995 LT.
213995 LT, Trilogy Apartments versus Jonathan Darby and Roshonda Wharton. As indicated, this matter was scheduled at 10 o'clock. It's now 10:52 a.m. by the court's clock. There are no unidentified persons in the court's virtual courtroom. There is no one in the court's virtual waiting room. Matter was scheduled at 10. It's 10:52 a.m. by the court's clock. Defendants having failed to appear. This was plaintiff's request to lift the Sarah stay that went into place on September 29, 2021. 133 days have passed. Ma'am, what is the status of this matter?
We haven't received any update as to the Sarah application, so we would be seeking a possession-only default judgment with rent to retain of $8,956.59, court costs of $186, for a total of $9,142.59.
Inasmuch as the defendants have failed to appear as requested by this court, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $8,956.59. There's court cost of $186 for a total judgment amount of $9,142.59. Plan to submit that judgment. Ma'am, thank you for your patience this morning. Unless you have anything else, you have a wonderful day.
Thank you. You as well, Your Honor.
Thank you. This is 214759 LT Pinewood Circle versus Chantel Moore. Mr. Katz and Ms. Moore, you were in the breakout room. The court brought you back as this is the last file for us this morning. Were you able to resolve the matter? Do you need more time to speak to one
Well,
another?
we're able to resolve it to some extent. I did indicate to Ms. Moore that she probably, after we're done with this, should speak with someone from legal aid, maybe Mr. Moravsky. She's got the similar situation as that last file, Your Honor. She's been approved by Sarah months ago. The funds have not found their way to my client. I've got tons of cases like this. I think that he can maybe help push the file through once there's a judgment in place and ensure that no eviction is entered. But I want to make sure that my client gets the money too. So at this point, Your Honor, there's currently a balance due of, hold on one second, $4,095 of past due rent, $177 of costs, for a total of $4,272. Now, I did indicate to Ms. Moore that she would have until February 22nd to have this matter resolved. I didn't finalize the consent. I did advise her rights, but I don't know where we stand at this point. I don't know if she's in agreement and allowing me to sign on her behalf.
Ms. Moore, the matter is before the court this morning on the plaintiff's request to lift the Sarah stay. That stay went into place back on November 10th, 2021. That was 91 days ago. The administrative order that governs these matters indicates 45 days from the stay through to the next hearing. Do you know what the status of your Sarah application is?
Yes, it is approved. I have been in contact with Wayne Metro every 2 days on the email. They are saying they don't know where the payment is. I've also went up there on Monday. They wouldn't let me in because of COVID. I told them that if I don't have the money by February 9th, which is today, because I thought today was the eviction day, I will get evicted. Again, they don't care. I don't not understanding. I've been paying my rent on time, on time since. I'm so behind because I lost my job. I applied for Sarah for assistance, and then when I got my job back, I've been paying, but I keep on getting fees on top of now. Like, I'm so behind in the hole. And then my Sarah application was approved. It was approved back in October, and they never sent the money. So that's what the judgment. That's what Mr. Katz was saying. Like, if I get the judgment, maybe they'll pay. But I'm just so
That's why I
behind.
think she should probably speak with someone from Lakeshore once we're done.
And I
with
have
this.
somebody for Lakeshore. I already spoke to them at the last court date, and then they knew about this court date.
I know, but they've got hundreds of people. So again, maybe
So
the
I
court can give you Mr. Moravsky's information, and maybe he can help you expedite this. It's been successful on a few of my other cases, Your Honor. It's unfortunate. This is not how this program should be working.
Ms. Moore, you've been making payments
Yes.
since November?
Yes. Well, I think he said that the first one was in October. As I've been getting my job, I don't want to be behind in my rent.
Yeah, she has made some payments, Your Honor. She paid $1,250 in January, $1,400 in February, but there were a few months, November and December, that were not paid. Monthly rent's around $1,200, and then she had a balance going into that. So, this accumulates. At this point, there's a balance of $4,272, Your Honor. And like I said, I think once she gets her Sarah money, I think that's going to pay most of the amount. Plus, there's going to be some required write-offs that my client's going to have to take care of on their end. It'll leave her maybe a few $100s left on her balance.
Thank you for that, Mr. Katz. I guess where the court is right now is we can do one of two things. If you've already started talking about a conditional dismissal or consent judgment with Ms. Moore, that's great. If you do not object to going over to my next landlord tenant date, which is March the 23rd, based on the fact that Ms. Moore has continued to make payments during the time that the Sarah thing has been pending, I'll do whatever the parties agree to do at this point.
I'm assuming that was February 23rd, Your Honor, or is it March?
No, sir.
Then I guess I would rather get that consent in place. I told Ms. Moore, if she's working with my client to ensure that these payments are received, they'll work with Ms. Moore. They'll even pick up the funds from Wayne Metro, which they've done. What I don't want to do is wait another 5 weeks or 6 weeks, come back in front of the court and find out that we're even further behind. I think we need a little fire on this one. It's unfortunate.
From a procedural from a procedural point, in as much as the plaintiff has not received the payment in full and more than the 45 days has passed, Ms. Moore, the court is actually required to lift the stay. We're 91, and that's why I go through the math of figuring out how long has passed between the stay and our hearing. So it's been 91 days. Yeah. Do you dispute the rental amount, the $4,095 as what's due and owing?
No, I mean, that's what I have with fees and back fees, all these fees.
Fees?
Well, it's late fees.
Well, it's rent and late fees. So that's where all that money's coming from. Because now I think the Sarah was only authorized for 36. I'm looking at the email for Sarah.
It says it's only authorized for 3,600. So
And there might be some adjustments to her account, Your
Yeah.
Honor, based on Sarah's requirements. I'm not sure, but even if she does receive the 3,600, that's still gonna leave her only a $600 balance. I'm guessing that once they have to adjust out some late fees, it might be pretty close to zero. It's anywhere from $0 to $600 is gonna be the balance after Sarah funds are received. What I would suggest is I can give till the end of the month, Your Honor, give an extra week so that maybe we can push this through even, at that point. As far as the
But your
rate.
number, this $4,095 that you're calling rent includes late fees that you're suggesting that your client would write off?
To some extent, the Sarah requirements would require them to write off a portion of those. I just don't know the amount. So I can't tell you 100% what that amount's gonna be, Your Honor. And
Okay. Are you doing this as a conditional dismissal or as a consent judgment?
I'd rather do it as a consent, Your Honor, and then I could do a satisfaction of judgment at some later date. It's a lot easier.
It's not a question of what's easier, Mr. Katz. I understand your position, but the thing is, I would rather Ms. Moore not have a judgment on her record or history when she's done what she's supposed to do and she's followed up, and Wayne Metro is indicating to her that her application is approved and has been approved for
Okay,
at least 3 months now. That's just.
I'll provide a conditional dismissal, Your Honor. You drive a hard bargain. I thought if I wore a tie and a jacket, I'd have a little more say today.
I don't drive a hard bargain, Mr. Katz.
I'm kidding.
Ms. Moore, Mr. Katz knows I'm giving him a hard time, and I understand this is serious, and I do want to be serious with you. If you acknowledge that there's $4,095 due in rent, plaintiff is making the request for the $177 in cost, which is what it costs them to actually file the case, serve the case, etc. The conditional dismissal would be $4,272. Also in there would indicate what that reduced amount would be, the amount that Mr. Katz was referencing, having to waive the late fees in order to receive the Sarah payments. If the parties enter the conditional dismissal, it says that this is the actual amount that's due. You'll have until this date to pay it. He signs it, you sign it. It gets signed by me. You have something to give to Sarah, to Wayne Metro, that says, we've done this. I need this money released. And I don't know if that's the squeaky wheel you need to get the money released.
and then if they don't, then I'm evicted again.
No, what happens is Mr. Katz still would have to submit a request to set aside the conditional dismissal. It's not that somebody automatically comes out if the money's not received from Sarah. It has to come back across my desk. And I make notes that Sarah was approved in October and that you've continued to make payments. And I would be disappointed and surprised if Mr. Katz ignored the fact that you continue to make payments over the last 3-4 months.
Yeah.
Who have you talked to from Lakeshore Legal Aid?
I was looking at my email because I thought I had it written down, but the email is just from somebody with the last name Banks. So I don't know if that's Spears. Sorry, Azalea Spears. That's who emailed me. But I don't know if that's who I talked to or somebody else.
Do you have your Sarah number handy, ma'am?
Yes. Do you need it right now?
If you can give it to me right now, I'd appreciate it.
Yes. C.178.500.279.OW-research-1.
That's way too many numbers. What number should I be using, Mr.
Oh, I
Katz?
don't
Can you
know.
tell from your end? I thought it was only 6 digits.
It should be 6 digits, but there's usually a dot after the first 6 that creates the research.
I don't know.
And by the way, it is a research, so there might be different rules that apply to this as well as far as the write-offs go, Your Honor. although I don't see an initial Sarah funding. If there's a recert, maybe there was a $10,000 payment back in April. Was that through Sarah?
It was either Sarah or eviction diversion.
Yeah, that would have been an eviction diversion, I think. But the question is, if it's a recert, where did the first funds go?
I don't know. So I applied in December for that one. December of 2020. So maybe that's Sarah.
Your Honor, if we could just put this through as the conditional dismissal, I mean, I'll give it until the 28th.
Mr. Katz, what I'm going to do over your objection, I'm sure, is adjourn this matter for 1 week. I'm going to put you on the docket for February 16, 2022 at 10 a.m.
Okay.
And Ms. Moore, at that time, what we will do is be prepared to enter either a consent judgment or a conditional dismissal. That gives you time to do a little bit more Sarah follow-up, okay?
Thank you, Your Honor. I think that makes sense.
Anything else, Mr. Katz?
No, I think we're good.
Anything else, Ms. Moore?
No, so I'm just reaching out to Sarah and I'm sorry, Wayne Metro, and telling them that I have a week now. So I'll do that.
Thank you, ma'am. And
Okay.
I appreciate your patience this morning. When you log on next week at 10 o'clock, I'll make a sticky to myself that I'll call your files, your Mr. Katz too, so you don't have to sit through this because we will have the second hearings again on some other unrelated
Thank you, Your Honor.
matters.
Okay.
Anything
Thank
else?
you.
Nope,
We're all
I'm
set.
good.
Have a wonderful day. Thank you.
Thank you.
Mary Ann,
Yes.
we have another thing at 12. So I'm gonna have us